Good morning, everyone. We are streaming live from European Forensic Institute to talk about the principle of common responsibility. It is an international legal principle which establishes that commander with superior-subordinate relationship may be held responsible for crimes committed by their subordinates if they have not taken necessary measures to prevent or punish them. This principle was introduced in international law and international criminal law to ensure that military and civilian leaders are held accountable for crimes committed by their troops or subordinates, even if they didn't directly commit such crimes. In fact, according to this principle, commanders must take responsibility for the action of their subordinates, not only when they have given them a direct order, but also when they should have known that a crime had been committed and didn't take adequate measures to prevent or punish them. The responsibility of commanders is a fundamental principle of international humanitarian law, which aims to prevent abuses and violation of human rights in situations of armed conflicts and emergency, but is not applied only in the letter, but also in other situations such as natural disaster or humanitarian crisis. In these cases, commanders must take measures to prevent abuses and violation of human rights, ensuring protection and assistance to people affected by the crisis. Now, let's go over a bit about the history of this principle. It was first introduced in the jurisprudence of the International Military Tribunal of Nuremberg, in which Nazi leaders were held responsible for the atrocities committed by the Second World War. However, it wasn't internationally codified until the Geneva Convention of 1949 and its additional protocol in 1977, which explicitly established the responsibility of military commanders for crimes committed by their troops. Subsequently, the principle was further developed in the jurisprudence of the ad hoc international criminal tribunals in the former Yugoslavia and Rwanda in the early 2000s. Finally, it was incorporated into customary international laws as recognized by the International Criminal Court in its jurisprudence, included the Bemba Gombo case of 2016, which will be discussed in more details in the sequel of this video. The ICC has established that the principle applies to crime against humanity and war crimes, as well as genocide. So, finally, at the national level, common responsibility has been recognized in many legal systems, although with some difference. In fact, in some countries, common responsibilities is considered a form of liability in which proof of the commander's fault is not required. In other situations, however, common responsibility requires proof of the commander's or person in authority's fault.
To better understand this principle, let's explain in simple terms some articles that govern it with reference to the jurisprudence of the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda. Firstly, the jurisprudence of international criminal tribunals ad hoc, such as the ones mentioned, has played a fundamental role in the creation and application of the principle of command responsibility. Through the numerous trials and the verdicts issued, these tribunals have helped to define and clarify the constitutive elements of the responsibility of commanders for crimes committed by their subordinates. It finds application within the article of individual criminal responsibility. In the statute of the International Tribunal for the former Yugoslavia, specifically in Article 7, individual criminal responsibility states, "A person who planned, instigated, ordered, committed, or otherwise aided and abetted in the planning, preparation, or execution of a crime referred to in Articles 2 to 5 of the present statute shall be individually responsible for the crime. Here we note that the superior is responsible regardless of their rank, as international criminal law does not require any particular qualities of the person who has committed an international crime. Specifically, the condition of being a superior of the perpetrator does not constitute either an element of the offense or a sufficient condition for imputability. Therefore, the quality of superior can be considered as an aggravating factor that intervenes in the assessment of the quantum of punishment. Quantum of punishment refers to the measure or amount of punishment imposed on an individual convicted of a crime. It is determined by the judge or court based on various factors, including the seriousness of the crime committed, the defendant's past conduct, their cooperation with authorities, their age, and the mitigating or aggravating circumstances of the case. In the same article, but in paragraph 3, one reads, "The fact that one of the acts referred to in Articles 2 to 5 of the statute was committed by a subordinate does not exclude the criminal responsibility of the superior if he knew or had reason to know that the subordinate was about to commit such an act, or had done so, and the superior failed to take the necessary and responsible measures to prevent such acts or punish the perpetrator." This article establishes two criteria to determine if a superior is criminally responsible for the conduct of their subordinates. If the superior has knowledge or reason to know, in the circumstances of the moment, that the subordinate is committing or about to commit a crime. This criteria indicates that the hierarchical superior may have had the mens rea required to incur criminal responsibility in two different situations. If he has knowledge of a crime or possible crime but does not act, he is considered an accomplice of his subordinate in the commission of the crime. The aforementioned knowledge is one of the constitutive elements of command responsibility, that is, the subjective element. In fact, the subjective element requires that the commander or hierarchical superior has had knowledge or presumption of the crimes committed by his subordinates. In other words, the commander or hierarchical superior must be aware of the illegal actions of his subordinates, or at least should have known them. This element is important to demonstrate precisely the fault of the commander or hierarchical superior. If he has reason to know, as he possesses relevant information, that his subordinate is committing or about to commit a crime, and ignores such information, he is criminally responsible for negligence, having failed in his duty to prevent or suppress any illegal conduct by acquiring any necessary information that puts him in a position to take appropriate action. In this case, we are dealing with the objective element, which requires that the commander or hierarchical superior do not adopt the necessary and reasonable measures to prevent or punish those responsible for the crimes committed by his subordinates. In other words, the commander or hierarchical superior must have failed to adopt effective measures to prevent the crimes committed by his subordinates from being perpetrated or to punish those responsible. The proof of the subjective element and the objective element is fundamental to demonstrate the responsibility of the commander or hierarchical superior for the crimes committed by his subordinates. Without proof of both elements, it is not possible to demonstrate the fault of the commander or hierarchical superior, and therefore his responsibility for the crimes committed by his subordinates. All of this is applicable only if there is a superior-subordinate relationship, as in order for the superior to incur criminal responsibility, he must have had the legal competence to take measures to prevent or suppress the crime and have had the material possibility to take such measures. In the context of military hierarchy, even a simple soldier who has had a small group of men under his order can be held responsible for the crimes committed by his subordinates. Two superiors can also be held responsible for the same crime simultaneously if the perpetrator is under their orders. International judges have specified that three elements must be present to establish the responsibility of a superior. Element number 1, the superior-subordinate relationship. Element number 2, the psychological element, represented by the effective or potential awareness that the subordinate is about to commit or has committed a crime. Thirdly, the omission conduct, consisting of not having taken all necessary and reasonable measures to prevent criminal conduct or punish the perpetrator.
The statute in Article 25, paragraph 3, letter B, states that who order a crime are punishable with direct responsibility. Subsequently, the command responsibility is regulated in Article 28, distinguished between military commanders and those acting on their behalf on one hand, and all other military and civilian hierarchical superior on the other. The norm considers the responsibility of the military commander to be more severe than the other of hierarchical superiors. The military responsibility of the commander or person effectively acting on their behalf extends to crimes committed by forces under the effective command and control, or when they have not exercised appropriate control over those forces. The responsibility falls on such a command when this military or person knew, or given the circumstances, should have known that the forces were committing or about to commit such crimes. This military leader or person did not take all necessary and reasonable measures within their power to prevent or suppress the execution, or to refer the matter or to competent authorities for investigation and legal action purposes. The concept of other hierarchical superiors includes all civilian hierarchical superiors and military superiors who do not have command authority or who have civilians under their command. The superior is criminally responsible for crimes committed by subordinates under the effective authority or control if they have not exercised appropriate control over such subordinates under the following circumstances: being aware of or deliberately disregarding information clearly indicating that such subordinates were committing or about to commit such crimes. The crimes were inherent in activities under their effective authority and responsibility. They did not take all necessary and reasonable measures within their power to prevent or suppress their execution, or to refer the matter to the competent authorities for investigation and prosecution purposes. The International Crime Court Statute requires that criminal acts of subordinate falls within the area of responsibility for which the hierarchical superior is responsible. This condition is not required in the case of a military commander. In fact, if the other conditions are met, they may be held responsible even for the crimes committed by their subordinates outside the area of responsibility, such as during leave. For the responsibility in the hierarchical superior to exist, three main elements must be acknowledged, all of which are enshrined in Article 28 of the International Crime Court Statute. The existence of a hierarchical relationship between the superior and subordinate, and the possession by the commander of effective control over subordinates and individual, Article 28A of the statute. The knowledge or knowability in the crimes committed by the troops by the commander, Article 28A and I of the statute. The failure of the commander to take all reasonable and necessary measures within their powers to prevent or suppress the commission of the crimes, or to refer the matter to the competent authorities for investigation and prosecution purposes, Article 28A II of the statute. Article 28 specifies the necessary and reasonable measure that commanders and hierarchical superior must take to prevent crimes committed by their subordinates, depending on the circumstances of the case. These may include training. The commander or person in authority must provide their subordinates with the necessary training to prevent the commission of crimes. For example, if this military operation, the commander must ensure that their soldiers are properly trained in the rules of engagement and international humanitarian law. Supervision. The commander or person in authority must regularly supervise the activities of the subordinates to prevent the commission of crimes. For example, if it is a prison, the commander must ensure that their guards are constantly monitored to prevent mistreatment or torture of the detainees. Establishment of control procedures. The commander or person in authority must establish control procedures to prevent the commission of crimes. For example, if it is a company, the commander must be established security policies to prevent theft or corruption by their employees. Punishment of those responsible. The commander or person in the authority must adopt punitive measures against those responsible for crimes committed by their subordinates. For example, If an employee steals from the company, the commander must take action to punish the employee and prevent further crimes. Commander responsibility does not mean that commanders are automatically guilty of crimes committed by their subordinates. The causal relationship between their action and the human rights violation committed by their subordinates and their actual responsibility for preventing punishing crimes must be demonstrated. Other criteria for establishing the responsibility of a leader under the principle of command responsible include the existence of a chain of command. It must be demonstrated that the leader had effective control over subordinates who committed crimes. Actual knowledge. The leader must have known or should have known about the crimes committed by their subordinates. Omission. The leader has failed to take necessary measures to prevent or suppress the crimes by their subordinates. The nature and seriousness of the crime committed. The crimes committed must be subordinate to a serious nature, such as war crimes, crimes against humanity, or genocide. In the end, I will put a difference between individual and command responsibility. The difference between responsibility and command responsibility is that the individual criminal responsibility refers to an individual responsibility for international crimes committed by them personally, regardless of their role in the chain of command. On the other hand, command responsibility refers to the responsibility of a commander or a superior for crimes committed by their subordinates under their authority and control. In this case, the commander or superior may be held responsible if they have not taken the necessary measures to prevent or suppress the crimes committed by their subordinates.